The state collects it, the state collects it, the state tests it, the state certifies it. You cannot.
You know, when we think about forensic science, our minds instantly jump to the absolute perfection of TV crime shows. It's that classic CSI illusion, right? We picture this flawless world where DNA, chemical analysis, and digital forensics represent absolute, unquestionable, and entirely neutral truth. But what if I told you that the way this science is actually applied in our real-world courtrooms might be hiding a massive constitutional crisis? Well, welcome to This Explainer. Today, we are focusing on a groundbreaking legal petition that is shedding some much-needed light on this exact issue. It centers on a fascinating concept called the doctrine of forensic equality, and it challenges the fundamental fairness of exactly how scientific evidence is used to take away a person's liberty. Okay, let's dive right into this. We're going to quickly map out this petition by looking at the unmatched power of the state, systemic flaws in AI threats, the constitutional question at play, what the petition specifically seeks, and finally, equal opportunity before liberty. So starting off with Section 1, unmatched power of the state and the stark imbalance in forensic evidence. This right here is the absolute core of the problem. On one side of the courtroom, you had the state. The state has the authority, the money, and the resources to collect forensic evidence, test it in a lab, and then certify it as undisputed fact. They literally hold every single lever of forensic power. But on the other side, we have the accused. And the accused has absolutely no matching structural right to independently check or verify a single piece of that evidence. The science just arrives at trial as this one-sided, unverifiable fact, and it's used directly to take away someone's freedom. So the state has all the power, and the accused is left totally vulnerable. And to put that vulnerability into perspective, zero. According to the petition, across the 12 distinct stages of a criminal investigation, there is a legal safeguard in place for the state at every single step. But for the accused, zero. There are no corresponding safeguards to ensure the science being used against them is actually accurate. The state wields infinite forensic power, while the individual holds absolutely none. Moving on to Section 2, systemic flaws and AI threats. We need to talk about what happens when science becomes opaque. The petition lays out some glaring institutional flaws that make this power imbalance incredibly dangerous. First off, forensic laboratories remain institutionally tied to the investigating machinery. Think about what that actually means. The person testing the evidence isn't independent from the person accusing you. Second, while we do have legal aid, it only pays for your lawyer, not for an independent forensic test. So if you're poor, you literally cannot afford to contest the science being used against you. Third, half of all scientific posts remain completely unfilled, which just severely strains the whole system. And finally, the law now makes a forensic expert's presence mandatory at serious crime scenes. This massively expands the state's forensic power, but does absolutely nothing to expand safeguards for the accused. Now, what's really interesting and honestly pretty terrifying about this is the sheer reality of the infrastructure we're relying on for justice. Out of 117 forensic labs operating in India, only 10 are actually accredited. 10. Let that sink in for a second. The vast majority of facilities generating the scientific facts that can send a human being to prison are operating without formal accreditation. And you know, the situation is getting even more complicated with new tech. Enter AI opacity. Investigators are increasingly using artificial intelligence tools, things like facial recognition and voice matching. The big problem here? These tools operate as total black boxes. They do not disclose the logic they use to make a match, and they don't share their error rates with anyone, not the defense and not even the judge. We are essentially allowing an unexplainable algorithm to act as an unquestionable judge. When these AI identification tools spread through investigations, this opacity isn't just a theoretical problem anymore. It becomes a routine, silent part of taking away human liberty. Which brings us to Section 3. The constitutional question, focusing specifically on Articles 14, 21, 22, and 39A. I want you to listen to this incredibly powerful quote derived from the petition's main argument. A lawyer, however able, cannot test scientific evidence they have no means to examine. I mean, it hits the nail on the head, right? You could hire the best legal defense team in the entire world, but if the state says a chemical analysis proves you're guilty, your lawyer cannot cross-examine a chemical. Without access to an independent laboratory or the funds to scrutinize the state's methodology, the defense is completely paralyzed. So the petition grounds this whole argument in 4 very specific constitutional articles. First, Article 14 protects us against arbitrary state action. Giving the state total forensic power with zero counterbalance, that is manifestly arbitrary. Next, Article 21 guarantees a fair, just, and reasonable procedure before taking away someone's liberty. Well, a procedure where only one side can verify the evidence is definitely not fair. Then, Article 22(1 ensures the right to a real and meaningful defense. But again, if you can't test the evidence, your defense is basically just an illusion. And finally, Article 39A promises equal justice and legal aid for the poor. But equal justice means absolutely nothing if only the state has the wallet to actually test the scientific evidence. Let's look at Section 4, what the petition seeks. These are 6 specific prayers for forensic equality. Let's move to and see how this builds a much-needed framework for fairness. Step 1 is straightforward, a formal declaration from the court that this current setup, giving the state exclusive power without matching opportunities for the accused, is constitutionally deficient. Step 2 is the core remedy, the right to independent reexamination. Now, to be clear, this isn't an unlimited free pass to endlessly test evidence. It's a proportionate, procedurally necessary safeguard that's subject to judicial control. Basically, if the evidence can take away your liberty, you should have a practical means to verify it. Step 3 demands disclosure. The state must disclose their underlying data, their methodology, and the scientific basis of their evidence. For AI tools, that specifically means forcing them to disclose the parameters and error characteristics, because evidence that can't be examined shouldn't be allowed to stand in a courtroom. Continuing with the prayers, Step 4 asks for forensic legal aid. This is about making that Article 39A promise a reality by extending legal aid to cover the reasonable cost of independent forensic tests for the poor. Step 5 directly addresses that tech threat we talked about by demanding minimum transparency and audit conditions for AI-assisted identification. If an AI output materially affects someone's liberty, its use simply cannot be opaque. Finally, Step 6 asks for the formation of an advisory expert committee. Now, this committee wouldn't decide guilt or innocence, and they wouldn't replace Parliament. They would just study standards for accreditation, validation, and AI reliability, making recommendations to make sure our safeguards actually keep up with evolving technology. Now, it is absolutely vital to understand the exact nature of this legal challenge. No interim relief is sought. No current trial proceedings are being stayed or paused, and no existing statute is being challenged or struck down. The changes they're asking for here are entirely prospective, remedial, and institutional. The entire goal is to fundamentally fix a structural deficiency for the future, not to derail the justice system we have today. Finally, Section 5, Equal Opportunity Before Liberty, and Rethinking Justice and Science. This quote from the source just beautifully captures the entire philosophy behind the doctrine of forensic equality. The Constitution doesn't promise equal outcomes. It promises equal opportunity before liberty is taken away. True equality and true liberty require so much more than just equal treatment on paper. They require the actual, tangible opportunity to contest the evidence itself. Which leaves us with this final thought to wrap up this explainer. If science can accuse, shouldn't both sides be allowed to question it? As forensic science and artificial intelligence increasingly dictate guilt or innocence in our courts, it's a question we literally can no longer afford to ignore. True justice just cannot exist in a system where only one side gets to hold the microscope. Think about that the next time you see a perfect, flawless forensic match on TV. Thank you so much for joining me, and as always, keep questioning.
Well, are you gonna do it? Do it. I paid to get it done.
संविधान सिर्फ एक किताब नहीं है, ये एक जीवित पेड़ की तरह है। जितना हम इसकी रक्षा करेंगे, उतना ये हमें मजबूत करेगा।